What's going on, y'all? Minutes with Mellon. Take a long video, make it shorter. Oh, we're burrowing in deep today, buddy. You hear what Mark Levin has to say about all this bullshit. But yeah, so just imagine like a little groundhog or like a mole rat or something, like burrowing into a hole. Let's get on it.
He's fine with that. I'm glad to know Joe Biden's fine with that because apparently Joe Biden believes that that is precedent, what took place in the New York court. He's very happy with it. Just let the process play out. Okay, let's let the process play out. So where are we with the Mershon Bragg decision? Because it's them. The rules to the instructions to the jury gave an inevitable result. So where are we? Where we are is if you make an effort to influence an election as a candidate, to prevent something negative from coming out in order to present a false positive picture, you have then created a criminal event. What's the law? Doesn't matter. What's the intent? Doesn't matter. Yet we actually have intent in the case of Joe Biden. What are you talking about? God willing, if Donald Trump is the next president of the United States, I am going to urge him, I'm going to lobby him to tell his Attorney General of the United States, let's stop playing games, to indict Joe Biden and indict Anthony Blinken. Because according to Bragg, Mershon, Biden, their media, and their surrogates, they committed a crime. In this case, we don't have to even recreate it through some phony link to a federal statute to revive a state statute. We don't need to get into all that stuff. We have federal campaign laws. It doesn't matter which part of the law, even though we have one, because that is the precedent that comes out of the New York case that Biden just supported. Okay, what am I talking about? I have in front of me a letter, October 19, 2020. Public statement on the Hunter Biden emails. It's about the Hunter Biden laptop. You're aware of this? 51 former intelligence spooks from all levels of the CIA, National Security Council, and all the rest of it, signed a letter, the purpose of which was to influence the election. And in the letter, they say, for a bunch of reasons, we write to say that the arrival on the U.S. political scene of emails, that's the Hunter Biden laptop, purportedly belonging to Vice President Biden's son Hunter, much of it related to his time serving on the board of the Ukrainian gas company Burisma, has all the classic earmarks of Russian information operation. And they go on to make their case. And not only that, they leaked it to the media. Well, who prepared that letter? The letter's a lie. The letter's a lie. The laptop is legit. It's being used in a federal case right now against Hunter Biden. It's 100% legit. The laptop, therefore, was dismissed as a non-issue as Russian disinformation 2 weeks before the election. 2 weeks before the election. In fact, in the final debate, Joe Biden pointed to a piece in the media citing the experts that this was Russian disinformation when it was brought up by Donald Trump. So the fact that it was used, the fact there was an organized effort, the fact that it was a negative story that was squelched to influence the election, there is no debate. I don't need a porn star to tell me that. I don't need a 400-time liar to tell me that. I don't need a crooked judge to tell me that. I don't need a crooked Soros prosecutor to tell me that. I don't have to play with the rules of evidence. I don't have to destroy due process. It's a fact. It's simple. It's open and shut. Game over. Biden and Blinken need to be indicted. God willing, if Donald Trump is president. Let me tell you why. They leaked this letter to a specific report at the Washington Post. How do we know? Because it was testified to that effect to Congress under penalty of perjury by the former deputy CIA director to Obama, Mike Morrell, who signed the letter. And so what happened exactly? Well, first of all, here's one of the stories that took place the same day the letter went out. Here it is, October 19, 2020, Politico, one of the favorite outlets for the Biden regime. And it says more than 50 former senior intelligence officials have signed on to a letter outlining their belief that the recent disclosure of emails allegedly belonging to Joe Biden's son, quote, has all the classic earmarks of a Russian information operation. And the story was planted. The outcome was the outcome they wanted. Right, Joe? Yeah, I think so, bobblehead. But what else do we know? Wall Street Journal opinion piece summed it up nicely. April 23, 2023. The House Judiciary and Intelligence Committees released portions of a deposition transcript exposing the origins of the statement from the 51 former U.S. spies declaring that Hunter's laptop had, quote, all the classic earmarks of a Russian information operation, unquote. The admission came from Mike Morrell, former deputy CIA director under Barack Obama. The letter served its political purpose of giving the media and Joe Biden the opening to dismiss the New York Post laptop scoop on Russian disinformation. Turns out the Biden campaign was behind the letter. Okay, case closed. But I got more. Mr. Morrell told Congress, under oath, under penalty of perjury, that he received a phone call from Antony Blinken. Last time I checked, he is our pathetic Secretary of State. On October 17, 2020, 2 days before the release of the letter, and 3 days after the New York Post published emails from Hunter Biden's laptop. Why were those emails important? Because they implicated Joe Biden in illegal foreign business schemes to get money from the communist Chinese. Mr. Blinken was then a senior advisor to the campaign and now Secretary of State. The letter says Mr. Morrell also, quote, explained that the Biden campaign helped to strategize about the public release of the statement. So they organized it, they drafted it, they had the entire process set up. They get it to certain reporters, and I admit it wasn't the National Enquirer, but it's worse. It went to all the mainstream radical Democrat Party media and was pushed out. Mr. Morrell says he then contacted an aide to former CIA Director John Brennan to say, quote, the Biden campaign wanted the statement to go to a particular reporter at the Washington Post first, and that he should send the statement to the campaign when he sent the letter to the reporter. Mr. Morrell acknowledged he had two goals with the statement to, quote, share our concern with the American people, unquote, and to help, and I quote, Vice President Biden win the election. All this took place shortly before the final presidential debate. Mr. Biden pointed to the Gang of 51 statement that his campaign helped to generate as proof that Hunter laptop was phony. Quote, look, there are 50 former national intelligence folks who said that what this is, President Trump is accusing me of is a Russian plan. They have said that this has all the characteristics. 4 or 5 former heads of the CIA, both parties, say what he's saying is a bunch of garbage. They create the letter. They get it signed. They leak it to media outlets who are happy to support him. They want him to win. Then he cites his own dirty work. To what? To influence the election. Even if he didn't have intent, it doesn't matter, according to Mr. Merchan. That's why this is an open and shut case. Mr. Morrell told the committee that following the debate, Biden campaign chair, now senior White House aide, Stephen Ricchetti, called to thank him for the statement. No doubt the Biden campaign had in essence generated its own disinformation, marshaling the authority of supposedly nonpartisan intelligence veterans to discredit a story that was accurate about laptop emails that were authentic. We don't even need to play around in state court. We don't even need to go through the motions of breathing life into state misdemeanor statutes. They need to be revived because the statute of limitation has run. No. I'll just point to the Federal Election Campaign Act. What part, Mark? I would point to the in-kind contribution part, but I don't have to point to any part. That's what happened in the courtroom. And Biden says it's a great process. Joe Biden and Antony Blinken, God willing, if Donald Trump is president, must be indicted if we're going to have an equal application of due process, or in this case, really no due process. That's what needs to happen. But we have another problem for Joe Biden, for which he needs to be indicted. We have a special counsel report by Mr. Hur that says he willfully disclosed classified materials. I quote. In other words, he violated the Espionage Act. Now, when he violated the Espionage Act, he wasn't president, so there's no presidential privilege that you can assert, or you can't assert that as head of the executive branch, he's immune from such prosecutions, which I think he would be, just my own view. But his violations occurred when he was a U.S. Senator, when he was Vice President of the United States, and when he was a private citizen. He got an $8 million book deal. In other words, he got $8 million for spewing classified information about Afghanistan meetings. That's a crime. If anybody else did it, it would be a crime. Now, Joe Biden believes in the rule of law, so let's stick with the rule of law here. The fact of the matter is that you can indict a president after they become president for actions they took having nothing to do with his presidency. That's not even what's up before the Supreme Court on immunity, which is the actions of a president when a president leaves. This is about the actions of a president before he was president, when he was vice president, when he was a private citizen, when he was a senator. Now, what about the statute of limitations? They don't matter. We have a case in New York. Statute of limitations? What statute of limitations? For goodness sakes. We just believe in getting to the bottom of this. We have so much evidence in this report from Mr. Hur of willful violations of classified information, it's hard to keep track. I know, but the Department of Justice said they're not going to act because Mr. Hur said and certified that Joe Biden is an imbecile. And plus, you can't indict a sitting president. Well, number one, he's no longer a sitting president. And number two, the imbecile defense is not one that a Trump attorney general has to accept. In fact, I've never heard of an imbecile defense before, but we have it. It's a first-timer. So Joe Biden is exposed, and in my view, should be indicted for willfully disclosing classified information, effectively selling secrets for a profit, and trying to cover it up. What do you think of that, Joe? Now, one other issue while I'm here, we have two great guests, John Yoo and Leo Terrell. Stick with us tonight. I do not understand the resistance or the confusion when I make the point that you cannot allow the case in New York to stand. Because the case in New York stands for what? Not just lawlessness, not just a violation of the Federal Bill of Rights as applies to the states through the 14th Amendment, and not just a violation of a presidential candidate's former president, the Republican putative candidate, and his due process and equal protection rights, although that would be bad enough. We the people have suffered. We the people have been attacked. The campaign process that's been in place since the beginning of the Republic has been altered by a Soros prosecutor and a Biden-conflicted judge. Now, does the whole country have to abide by that now? And they It's not a matter of right, but discretion, sparingly used by a court. To justify the granting of any such writ, the petition must show that the writ will be in aid of the court's appellate jurisdiction, that exceptional circumstances warrant the exercise of the court's discretionary powers, and that adequate relief cannot be obtained in any other forum or in any other form other than this court. You file the notice of appeal. As I said, you ask for a stay of the trial court from the New York court's immediate expedited review you seek. You file applications for common...
Which he's not going to get an immediate expedited review. They're going to slow walk the fuck out of that. So it stays as long as possible. That's why they're saying, fuck, it's either go to jail or be elected president. That's pretty much his two options.
Common law writs, writ of prohibition, writ of mandamus, it doesn't really matter for our purposes. What you're trying to do is get the case to the door of the Supreme Court.
Yeah.
You have 1,000 federal constitutional reasons for doing it. And the exigent circumstance is it's going on right now. The constitutional violations are affecting the election as I speak. Every minute that goes by, more damage is done. It becomes more difficult for the Supreme Court to undo it. I don't know why this is complicated. I don't know why people resist it. Well, it's a long shot. It may not work. So what? If you don't take a long shot, you take no shot. But it's not.
Yeah, pretty much. There's also another video that he did. Well, not him personally, but where's he at? Where'd he? No, not that one. Fucking Fauci's worthless ass. This one. No, I'm gonna skip ahead, but he actually shows the actual precedents.
precedent. The argument would be that the payments were made to protect Trump's reputation and avoid public embarrassment, not to influence the election. Therefore, these payments are a form of protected speech under the First Amendment. The legal precedent for that claim comes under Buckley versus Vallejo, 424 U.S. 1, 1976. The Supreme Court held that expenditure limits in the Federal Election Campaigns Act of 1971 violated the First Amendment. The ruling emphasized that political spending is a form of protected speech. Then we have an intent and mens rea argument. For a conviction under campaign finance laws, the prosecution must prove that Donald Trump had the specific intent to influence the election. If the payments were made for personal reasons, such as avoiding embarrassment, this specific intent isn't present. We've got United States versus Pomerening, a case that emphasized the necessity of proving specific intent for criminal liability, and then we've got McCormick versus United States. From 1991, the Supreme Court held that a public official's acceptance of money does not constitute a violation of the Hobbs Act unless there is a clear quid pro quo arrangement. The principle of requiring clear intent can be analogized to Trump's situation. He's not the one who signed the checks. He's not the one who listed the expenditure as legal services or legal expenses. He's not even the one who came up with the idea. It was all Michael Cohen. From his perspective, he's a public businessman, a public figure, and he's got an individual who essentially is coming out saying that she's gonna spill the beans about their alleged affair. He had a personal interest to make that issue go away. The argument can very easily be made that that's a personal expenditure rather than a campaign expenditure. What was the thought at the time? The word willfully within the world of law has a very specific meaning. Did Donald Trump willfully break a campaign finance law, or is he just a public figure who paid hush money to somebody who was extorting him? How do you prove that intent? Because proving that intent is supposedly what turns this thing into a misdemeanor charge. Paying hush money, I mean, that's not even a crime. That intent is what supposedly turns this whole thing into a felony. The question is, have they proved intent beyond a reasonable doubt? Absolutely not. It's a concocted legal scam, a twisting of the law to take a felony and make it stick. There are holes all over this case. Did they prove the intent? Has the statute of limitations run its course? Does Alvin Bragg even have jurisdiction as a state-level prosecutor to be bringing this federal case? Does the New York legal system get to decide who runs for president? Do they get to decide based on their own local laws that they twist and manipulate to pretend as if a federal crime was committed? Do they get to dictate for the rest of the nation who gets to run for president and who doesn't, because they'll just basically throw whoever they're up against? And does New York just get to do that? Appeals season just got started. We'll have to see exactly what happens.
So if you recall, New York changed the statute of limitation laws just so they can indict Trump. Like, if that's not going after a fucking political opponent, I don't know what is. It's fucking sick what they're doing. But there's so many holes in this shit. And I mean, if you really want to burrow in, go into it deep, you're just like mind blown of how this even passed. Like, how they even got a conviction is just like, what? But yeah, I just thought I'd share that. Good luck, y'all. Stay safe.